got your notebook. There's more.
A Turning Tide, Assange and Netanyahu. I'm Joe Lauria, the editor-in-chief of Consortium News, reporting to you live from London, where on Monday, imprisoned WikiLeaks publisher Julian Assange won a rare victory in a British court in his battle against extradition to the United States. And on the very same day, an even rarer occurrence took place. The International Criminal Court's chief prosecutor asked for an arrest warrant for Israeli Prime Minister Benjamin Netanyahu over his conduct in Gaza. Also this week, Norway, Ireland, and Spain recognized the state of Palestine, which the United States and Israel arrogantly deny exists. Are these isolated events, or are they indicators that a tide is turning against supremely powerful interests that seemed for the longest time impossible to move? With us today to discuss these issues are former British diplomat Craig Murray, legal and political analyst Alexander Mercouris, and joining us for the first time on CN Live, a U.S. constitutional expert Chip Gibbons, and welcoming back to the program, journalist Chris Hedges. Thank you all of you for being with us. Craig, I'd like to talk to you first because you were inside the courtroom. You wrote another brilliant piece about it. And before I saw your article, we gave a title to the show called A Turning Tide. And then I went to look at your piece, and your headline is a tide, the turning of the tide. So clearly we're thinking along the same lines here. Now, although the High Court of England and Wales rejected most of the serious grounds of appeal sought by Assange, including the new evidence that the CIA spied on him and his lawyers also plotted to kidnap or kill him, it did in the end find the narrowest grounds upon which imprisoned WikiLeaks publisher could appeal the Home Office's extradition order to the U.S., where he faces up to 175 years in prison. Those grounds are that the U.S. was unable to assure that Assange could mount a free speech or First Amendment defense at trial in line with British extradition law. So, Craig, this rare court victory has apparently left you optimistic when I spoke to you, and I'd like you to tell me why you're optimistic about what happened on Monday.
Yeah. I think, firstly, there's the narrow legal point itself, where the United States has really painted itself into a corner, and I don't see how they get out of it. The court has said that because of the risk that he would suffer discrimination by nationality, contrary to the Extradition Act itself, the United States must give an assurance that he would be allowed to make a freedom of speech defense under the First Amendment, which was not debarred by nationality. Now, it's very important to understand the court isn't insisting that the freedom of speech defense would override all other considerations. They're not insisting for an assurance in advance that freedom of speech would trump so-called national security considerations, for example. What they're insisting on is the narrow point that it won't be disallowed on the grounds of nationality. And the United States is in a bind because, firstly, their prosecutors, Attorney General Comberg, had already given testimony to the court by way of affidavit saying that the prosecution may make that point. That may be something the prosecution ask. Secondly, there's case law in the United States saying that a non-US citizen operating outside the US territorially cannot claim constitutional rights. And thirdly, the executive can't bind the court anyway. So even were the United States to say that the prosecution will not push that argument, they can't promise that the judge won't rule it out on grounds of nationality. So I don't see how they beat that point. I don't see how they beat it at the forthcoming hearing. So that's the technical point, if you like, on which the United States seems to be in a real bind over the assurance that's been asked. And the second point is this more general point, that I do think this represents a turning of the tide. I think it's against a background of much wider support for Julian Assange. I think it's against the background of his own Australian government having supported him, because if you don't have the support of your own government, frankly, you're on a very sticky wicket in the first place. It's not a sufficient condition for beating extradition, but it's pretty well a necessary one. And the judge said, Judge Sharp said, and it was very striking, given what is at stake here, when she was intervening, or when she was making a ruling against effectively a motion by the prosecution, a request by the prosecution to limit the number of defense speeches, the judge said, given what is at stake here, I'm going to let them speak. And that seemed to be from the bench, a statement we haven't seen before, that they recognise the importance of the wider issues. So I think on the narrow point, the United States is in big trouble. And I think on the wider point, I think the tide has turned in the whole atmosphere around the case. So that's why I am optimistic at this stage.
Joe, I think you might be muted, or I've gone deaf. I'm not sure which.
Sorry, Craig, why did it take 4 years for these two issues to really surface in this case? The death penalty issue, which was resolved. The Home Office never asked for that routine assurance from any country that's asking for someone from Britain to be extradited that has the death penalty. Britain has to ask them to give the assurance. That didn't happen for 4 years here. And it was the court that had to ask the United States to do that. Why did it take 4 years, as well as this First Amendment issue? It seems quite strange that this happened at the very last moment.
Why the Home Secretary hadn't asked because really for the Home Secretary to initially request the death penalty assurance, and that's a routine bit of business. Why that hadn't been done, it's difficult to be sure. It may have been some idea that by not doing it, by having the looming threat of the death penalty, that puts still more pressure on Assange. It's hard. It's hard to be certain. Why this? But this final assurance request on the argument of discrimination by nationality, if you like, it's simply the last argument standing. The argument's always been there. And just as all the other arguments have been knocked away by the court, right, that's the last argument left standing. And again, if you asked me to move away from from what's happening in court and what the actual issue being discussed is, to what's behind that, what's happening behind the scenes, if you like, I think there's a very good argument that the British establishment is fumbling its way towards a situation where it can stop the extradition without making a ruling that fundamentally is hugely mind-blowing in terms of the British state saying the United States was committing war crimes which had been revealed, or the United States was illegally spying and stealing documents from Julian Assange, or the United States was plotting to kidnap and kill Julian Assange. It's quite a big thing for a British court to turn around and say any of those. Was what they've managed to do is find a much softer technicality on which they might be able to stop it. And I think that's, and don't get me wrong, I don't believe that there's any mastermind or committee sitting around plotting this. I just think they're fumbling their way towards the outcome they rather desire. And this is where we've got to.
Alexander, do you share the view that this is a major change, a significant change in what's happening in Assange's case?
I think it is a major change. And can I just say, I agree with much of what Craig says, but I would actually go further. I think this is a more substantive decision than perhaps Craig is suggesting. And I'll explain why. Because, of course, they're saying, yes, we are granting leave to appeal because he might face discrimination in terms of invoking his First Amendment rights his First Amendment defense in the United States. But by saying that, the High Court is saying that he has or ought to have a First Amendment Act defense in the United States, and that if he is sent to the United States and deprived of his right to do that, then he could be also, in effect, be denied his human rights in Britain. Now, that, it seems to me, is actually quite a substantive issue, because it suggests that some people within the court, and I think this is where the point about the stakes, the high stakes involved, that comment comes from, are starting to understand that there is an issue here which relates to the work of the press, of the media, and that what the United States has been doing is in effect trying to restrict the rights of media, of journalists operating outside the United States who are not American citizens and who they say are not therefore eligible for the rights under the First Amendment. So I think this is actually quite an important decision. But I will agree, I will say this, I agree with Craig in this absolutely critical respect, which is that having decided it in that way, having come to that point, having reached that point, it's very difficult logically now to see how the court, the High Court, can refuse the appeal when it is heard. Now, I don't think they wanted to be put in this position. I think they did want, basically, to send Assange to the United States, hoping that all of these issues could be worked out there. And I think that is why they asked for those assurances, because they didn't need to ask for those assurances. They could have simply granted leave to appeal, but they chose not to. They prompted the United States to come up with assurances. And I think they were hoping that the United States would come up with assurances that they could accept and work with, and which they would allow them to allow the extradition to happen. And the big question is, why did the United States not give assurances? Well, Craig is absolutely right. There's case law in the United States, there's policy in the United States, policy decision in the United States, which says that non-American citizens cannot cite the First Amendment in cases like this. But based on what we have seen from the High Court in the past, specifically in this case, they seem to be prepared to accept assurances which appear to cover their points. The point about the assurance the Americans gave in this case is it didn't come anywhere close to doing that. It was almost defiant. It basically it used words like seek. It effectively admitted that there was almost certainly he would not be able to rely on the First Amendment protections in the United States. They then went off on a disastrous line of argument, saying that the First Amendment didn't even apply anyway to the kind of things that he had done, which would, of course, only have confirmed the judges that if he is sent to the United States, he's not going to be able to rely on the protection of the First Amendment. And that's why we have the decision that we did. So the question is, why did the United States come up with an assurance that was so completely inadequate to what the High Court was asking for, and why they took the line they did? And I think the short answer is that the United States does want to prosecute people who are not Americans for doing the kind of work, the kind of journalistic work that Julian Assange has used to do and wants to do again, and who are not Americans. And they don't want to give even the smallest indicator that there might be any doubt about that. So because they had to take that very, very hard line on this issue, which is for them a key issue. That is why the High Court made the decision that it did. So in a way, seeking the assurances from the US has smoked them out. It's made it quite clear what their agenda is, which is to police journalists around the world and to prevent them from saying things that the United States and disclosing things that the United States doesn't want them to disclose. So it's had that effect, but it's also landed them in the situation that they now find themselves in Britain, where they're now facing an appeal where, as I said, on the facts and on the law, it looks like they're going to lose.
Of course, even if the Department of Justice had wanted to give a guarantee that he can use a First Amendment defense, they couldn't, because they're in the executive branch, and that's a decision of the judicial branch. So they're stuck. They could not give that. But even then, Kronberg never said he would. Yeah, sorry.
Yeah, they couldn't give that kind of assurance, but they could have gone. I think they could. I think the High Court was hoping that they would come up with a clearer, stronger assurance than the one they did. Otherwise, why seek an assurance at all? Why not simply grant leave in February, which frankly is what they should have done? If they see that there is a problem here, it's not for them to prompt the United States to provide assurances, to tell the United States of America, how it should conduct its litigation. Instead, they asked the United States to come up with assurances, which suggests to me that if the Americans had come up with something more intelligently worded, and lawyers can come up with very intelligent, very clever wording when asked to do so. If they'd come up with something like that, they'd have probably said, well, look, it looks as if he's not going to be discriminated after all. We can find a way around. Let's send him to America and the Americans can sort it out. And then, of course, if he's in America and it turns out that he doesn't, he's not able to rely on the First Amendment, well, the British could wash their hands of the whole thing, say, we did our best. We had the
You have people all across the country and world protesting, and the response of governments have been to basically shut down what we have left of freedom of speech. So we're in an incredible moment right now, historically. And it does feel like something has to change, although I know there's been other points in history where people have felt like something had to change and it didn't. So, but I'm a little bit more optimistic about this one.
Right. Thank you, Chip, for that. The question of whether Palestine has the jurisdiction, is there jurisdiction in this case? When Palestine became an observer state in 2012 at the General Assembly, it was after that they were a state. They were considered a state. They are already a state. I had this conversation, an email with Alexander before the show, and just this week, or just yesterday, Norway, Ireland, and Spain have declared that they recognize the state of Palestine. And there is a perception that is in the media, mainstream media, that's completely wrong about this, and it's fed by the Israeli and the U.S. government. And that is that it's up to Israel and the United States to determine whether Palestine is a state or not. Because if you listen to the American representative Robert Wood at the UN in the vote that they had some weeks ago at the General Assembly about Palestine becoming a full member, he said there has to be negotiations between Israel and Palestine to determine statehood. And this is completely wrong in my understanding. And I'm going to ask Alexander, who's the lawyer, because it's bilateral states that recognize other states that creates statehood, not a vote at the UN. The UN does not vote for statehood. The UN, Article 4 of the UN Charter says that any peace-loving state can apply for membership of the UN. So you have to be a state first before you can apply. And they are a state. They're an observer state, and the vote was to make them a full member state now. But under the Montevideo Convention, which is still in force and is customary international law, from what I understand, it's a bilateral recognition, and then now more than 140 nations recognize Palestine. And Colombia announced today they're going to put an embassy in Palestine, I guess somewhere in Ramallah. So I want to ask you, Alexander, just because I'm getting a lot of trolls who are coming after me saying that, of course, Palestine's not a state, because they're reading in the New York Times. They're reading that this has to be negotiated between Israel and Palestine. And it's not the way I see it. How do you see that, Alexander?
What creates a state is the decision and will of the people who constitute the state itself. This is a nation, and there's always arguments about what a nation is. But if there's a nation, and that nation defines itself as a state within its territory and its borders, then we're already taking a huge step in saying that there is a state in terms of international law. If other states start to recognize that state, which has been created by those people on their territory, then again, I think the legal position is absolutely clear. Beyond a certain point, the fact that a state exists is incontrovertible. The existence of a state, in other words, is a matter of fact. Now, I don't think anybody looking at the situation of the Palestinian people today would dispute that there is a state there. The fact that large parts of that state are in a condition of occupation does not itself mean that we are not talking about a state. And I think that is widely acknowledged around the world, that Israel doesn't want to acknowledge that because it is in conflict with the very concept of a Palestinian state. It is not something we should support. It is something we should be concerned about, because by denying the existence of the state itself, they are also calling into question the rights of the Palestinian people and whether those people who are there are in fact even a people at all. So I think, Western governments that take this line are on a very, very slippery slope indeed. Now that's, I think, my view. Perhaps not all lawyers would agree with it, but it's certainly my view, and I know an awful lot of lawyers who would.
So it looks as though a tide definitely is turning in the Assange case, in the world's view of Israel, and maybe now also on recognizing that Palestine is a state and has been a state, because Spain, Norway, and Ireland, Western European countries, apparently riling up other Western European countries, this decision, have now come forward to recognize Israel. None of this would have happened if Israel didn't respond the way they have to October 7th. So one could say they're digging their own grave. Chris Hedges, if you have any final words on any of the things we've discussed.
I don't think there's any coming back from this. That doesn't mean that Israel won't be able to perpetuate its apartheid state for some time, but it's certainly lost the next generation. I don't think it can peddle the myth of the only democracy in the Middle East and flowers blooming from the desert and all the other stuff that has acted as a kind of subterfuge for this settler colonial project. I don't think that's. I think in that sense, the mythology of Israel has been obliterated. It is now seen for what it is. For those of us, of course, I spent 7 years reporting out of the occupied territories and on a daily basis kept attempting to expose. I think it's now exposed and it's not going back, and that's significant.
Well, Alexander, if you want the final word.
No, I think it is an important, I think it's a key event, actually. I mean, it shows that also control of international law is starting to shift. And this is an important thing because international law, until very recently, has ultimately been very much controlled by the Western powers, the legal communities of the West. They've been the people who've decided how it would work. International criminal law, international humanitarian law. The United States has made a huge issue about international humanitarian law. That they're saying that international humanity, the fact that they interpret international humanitarian law enables them to interpret other parts of international law as well. And now we see, for the first time, an international court actually rebelling against this. It's not happy to do it, doesn't want to do it. Karim Khan doesn't want to be sanctioned by the United States, but they've done it. And I think that is a seminal moment. It's a seminal moment for the Palestinians. It's a seminal moment for the Middle East, for Israel itself, and for the world. And just to quickly add, very quickly, about the difference between the ICJ and, of course, the ICC. The ICJ looks at disputes between states. The ICC brings cases against individuals. So for the first time, individual Israeli officials, Netanyahu and Gallant, are facing indictments. And that is always a very uncomfortable situation to be in.
Well, they handed it on a silver platter to the ICC in their statements of intent, of genocidal intent, which were extraordinary, and they keep happening. And then they back it up with actions.
Absolutely. I mean, their rhetoric has been astonishing. And by the way, Karim Khan just very, very briefly squirrels in to his statement the fact that one of the facts that's led to this decision to request these arrest warrants is what he extraordinary language he uses, the statements of the group that is supposed to have carried out all of these things that he's asking for arrest warrants for. So does the group just confine itself to Netanyahu and Gallant, or are we talking about a larger pool of people? And if it's a larger pool of people, why not seek arrest warrants against them also? And if it is just Netanyahu and Gallant, which is absurd, by the way, then why not say so? Why not say the respondents to this request? Why not use use this very strange word, group? But it's the kind of thing that Karim Khan is hiding behind, because to say again what Chris Hedges and Craig and Chip have all said too, he didn't want to do this. This is not what he wanted to do. And in some ways, that makes what's happened even more significant.
Very good. Thank you, Alexander Mercouris in London and Chris Hedges in Princeton, New Jersey. Chip joined us from Annapolis, Maryland, and And Craig Murray was in Edinburgh, Scotland. Kathy Vogan is back in Sydney, Australia, our producer, and she intervened with some important questions as well. And we thank you all for joining us today, and we'll see you soon on CN Live. Goodbye.
Get out your notebook. There's more.
If you are a consumer of independent news, then the first place you should be going to is Consortium News, and please do try to support them when you can. It doesn't have its articles behind a paywall. It's free for everyone. It's one of the best news sites out there, and it's been in the business of independent journalism and adversarial independent journalism for over 2 decades. I hope that with the public's continuing support of Consortium News, it will continue for a very long time to come. Thank you so much.